Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hello, I'm Natalia Angelini.
And I'm Sydney Osmar.
Welcome to Hull on Estates. You are listening to episode number 662. Today, we're going to be discussing First Dealings Exemptions. And I think it's a really great topic to think about because it's March, it's spring, we've got the real estate market picking up again. People may be looking at transferring real estate. So we thought this might be kind of a nifty topic to cover.
That's right. And while we don't practice real estate law, we do think that this is a topic that's something estate practitioners it's relevant to us when we're advising our clients, especially around whether or not probate may or may not be required to administer real property from an estate. And so whether or not something's called the First Dealing Exemption applies to their certain situation is something that we think estate practitioners should be aware of. They should be able to identify the First Dealing Exemption, know what it is, know how to issue spot it. And ultimately, when dealing with questions of real property, we're going to defer to the real estate lawyers out there, but it's something that we still need to be aware of. Because at the end of the day, if it's something that we can flag for our clients, we may end up saving them a fair amount of money.
That's right. That's right. And the general requirement under the Land Titles Act, right, is that upon the death of an owner of property, the estate trustee is to obtain a certificate of appointment of estate trustee. So there is the typical exemption that we know about, which is for estates under $50,000 and under, so small estates. And there's another exemption, which we're covering today, which is the First Dealings Exemption. And what that means is, since the automation and administrative conversion of properties from the Registry Act to Land Titles Conversion Qualified, that's LTCQ, that we'll refer to going forward. So that's where the First Dealings Exemption comes into play. And properties that are LTCQ are always exempt.
That's right. So what you're looking for to see if a property qualifies for this exemption is whether the deceased owner acquired the property when it was registered under the Registry Act, that the property has since been converted to LTCQ and remains in LTCQ, and that the deceased owner still owned that property at their death and that they died with a will. The exemption then is available because it actually will be transferred in accordance with the Registry Act rules, which doesn't require a certificate of appointment of estate trustee for dealings with land. It does not apply for intestate successions, and that's because the Land Titles Act actually requires in every circumstance where someone dies without a will that there be a certificate of appointment when you're coming to transfer a piece of land. And it's never available if the lands are already converted into Land Titles Absolute or Land Titles Absolute Plus. So when you're looking for this on the parcel register, it's usually under the estate qualifier field on the parcel register, and you should be seeing something like LTCQ or Land Titles Conversion Qualified. And sometimes we'll see on the parcel register a note that it's the first transfer from book or first conversion from book. And this doesn't mean that it's immediately applicable for the exemption. It could just mean that the property is being, for the first time, from being transferred from paper to an electronic register.
Right. And that's a good point, Cindy. We're looking for the estate qualifier, right?
That's right.
Let's say that right. And it's usually on that left-hand upper portion of the parcel register.
That's correct. Yeah.
So let's talk about a couple of situations where a property is not eligible for the exemption. And one is condominiums. So most condos are rarely eligible for that because they're constructed on lands that are LT Absolute or LT Absolute Plus. I think there are some condos in Southwest Ontario where the exemption may apply, but again, talk to your, we'd recommend that you seek real estate advice so you're sure that the exemption would apply to that property. And another situation where the exemption is not available is on an intestacy. So if someone dies without a will, they have to apply for probate. and it's going to be required in every instance.
That's right.
So you can't get an exemption. One other thing that we wanted to cover was transfers after conversion. So after conversion to LTCQ, what happens if the property gets transferred? And in short, you lose the exemption.
That's right. And it doesn't apply. The exemption, you lose it also, even if you are doing non-arm's length transfers to family members, or if you're transferring for nominal consideration, natural love and affection. We see these terms pop up on transfer documents and deed titles. But in those circumstances, it is still lost. It is still considered a transfer, and it's now officially out of it's into land titles. And it's seen as the person who receives the property. They never owned the property under the Registry Act, so they don't have access to the exemption.
It is good to know, though, that mortgages, notices, leases, any kinds of restrictive covenants, and easements, those do not serve to bump you out of the exemption. Right. Yeah,
that's right. That doesn't bump you out. And another thing that doesn't bump you out, which we can segue into, is the case of joint tenants. So if two owners purchased a property or came to acquire the property under the Registry Act and they held it as joint tenants, if one of them dies and the property has subsequently been titled into LTCQ, that property transfers on right of survivorship. So the exemption actually doesn't have to come into play at all, because it passes outside of the estate and passes to the survivor on survivorship. And so the survivor thereafter, when they died, they do still have access to the exemption if they otherwise qualify.
Yeah. And what about tenants in common, Sydney?
Yeah, so for tenants in common, obviously, if the ownership's not passing on survivorship, but if it was acquired under the Registry Act and otherwise fits the requirements that we discussed at the beginning of this podcast, those people, their 50% or for whatever interest that they held in the land, they would have access to the exemption if they still otherwise qualified for it. And another example where the exemption will still apply and it's not vitiated, similar to what you mentioned, Natalia, with registering mortgages or restrictive covenants, self-to-self transfers also won't vitiate the exemption. So if you have a situation where two owners acquired the property, and let's say they held it as tenants in common, as joint tenants, and they wanted to sever title to hold it as tenants in common, that act itself won't vitiate the exemption.
That's right. And another kind of interesting scenario is when we have a person who acquires multiple undivided shares in a property. They may qualify. And the best way to illustrate that is to just maybe give an example. So if you've got a husband and wife and they've bought a property as tenants in common, let's say 50-50 as per usual, and they bought it under the Registry Act, and the husband passes away, leaving his half interest to his wife in his will. His estate is entitled to the exemption for that 50%. And the wife, when she passes away, is entitled to the exemption over 100% of the property.
That's right.
So it's a unique little, interesting piece of information for that kind of scenario, which actually probably isn't so unique. It probably happens more frequently than one would think.
Probably.
Another interesting piece of information we thought is the concept of no tacking on. So if you acquire land and there's abutting land that is already registered under land titles, the exemption only applies to the original parcel. So that abutting land does not fall into it and is not subject to the exemption.
That's right. And so when it comes time to actually see to these types of transfers, and whether you qualify for the exemption, it's something we mentioned at the beginning, we'd obviously defer to a real estate lawyer for that. And ultimately, it would be a real estate lawyer who would be preparing the documentation required for that. But there are certain special statements of law that are required as part of the transfer that would have to be filed. And so if the exemption applies, as part of that statement, you have to include a statement of law that says no application was made for a certificate of appointment for a state trustee, and that this transaction is the first dealing after the property was converted from registry to land titles by the ministry. So this is a situation that can be not an issue, but something that the real estate lawyer might have to address by having a follow-up statement of law, where you have a situation where a state trustee has, for example, there's a primary will and a secondary will where they may not require probate under one will, but they do require probate under a second will. So technically that statement of law wouldn't be correct if you did not have some qualifier in there that, there is a certificate of appointment that had an application for one that has been made, but it's not being relied upon for that transfer, something along those lines. And again, that's something that you would go to a real estate lawyer for, and they would have the language for it, but it's just something to be aware of.
Yeah, absolutely. So I guess this brings us perhaps to our final point, which is succeeding estate trustees. So if an estate is entitled to an exemption, but let's say the executor passes away or is replaced by a succeeding estate trustee, the exemption continues to be available because it attaches to the estate. So that's a comforting piece to know that there won't be issues when there's this transition of that role.
Yeah, no fear of losing it over something like that.
Right. So Sydney, unless you have any other thoughts, unless you do, I think that concludes our podcast.
No, I think that's it for me.
Okay, well, until next time, we want to thank you for listening. I'm Natalia Angelini.
And I'm Sydney Osmar.
Should you have any questions, please email us at info@hullandhull.com or contact us through the contact page on our website. Thank you.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.